Hi, welcome to the It's Your Money and It's Your Estate Spring 2025 workshop series, brought to you by our 501c3 nonprofit organization, Financial and Estate Literacy. Our mission is to empower you to take control of your finances, your estate, and your charitable giving decisions. For the past 25 years, our founder, Peter Kote, as well as our entire team, have been providing these free, unbiased, and accessible 6-week workshops all over Orange County, California, as well as online, to help you make informed decisions that align with your unique needs and values. Now, let's start the program. This webinar is the third session of the It's Your Estate workshop series. The topic of the day is wills and trusts. Our moderator is Peter Kote. Our guest speaker is Elise Frederick. And this webinar is brought to you by Chapman University. Enjoy the workshop.
Cheryl, come online. We're going to do wills and trusts today. We're in our third session. Before this, we've done the general introduction. We spent a lot of time on the Advanced Healthcare Directive and the Durable Power of Attorney. And today, we're actually going to get into what is a will and what is a trust. But before we do, Cheryl, let's see if we can get your ask first up on the screen, and here it comes. Cheryl, you're with a law firm, Ferruzzo and Ferruzzo. Talk a little bit, because you've been there a few years. Why is Ferruzzo and Ferruzzo so special in the community?
Well, we are not quite a full service firm, but we do handle business litigation, corporate real estate. But I think one of the real hallmarks of this firm is that we have a very dedicated and fairly large estate planning and trust and probate litigation department.
Yeah.
Most law firms have an estate planning attorney, or maybe two or three at most. Many of them don't do trust and probate litigation, and many do not do probate. As we talk about wills, you'll understand why a law firm might not want to be doing probates. We
Yeah.
don't get paid until the end of the case and the case is dragged. But we have a really good expert team at handling probate for people who don't plan or didn't plan well. And we have a group of really good expert estate planning attorneys, several of whom have their LLMs, which are advanced degrees in tax, that can help the very high-end net worth individuals with their business succession planning. And we also have trust litigation department. Trust litigation in the United States is the highest wave, if you will, of litigation, unfortunately. But that is the case, and we have several attorneys dedicated to that practice.
Yeah. I consider, and the thing of it is that you don't have offices all over the country, but you are a kind of a national firm locally because of your expansive group, and that you can handle smaller estates and you can handle multi-billion-dollar estates.
That's correct, and we do. There is no floor at the bottom, and we're willing to take estates as $100 million.
So you have a Juris
Represent
Doctorate degree, which is to practice law. How many years have you practiced law in the estate planning area?
Oh gosh, that's a rude question. Let's see. Let's just say several decades.
Several decades. In other words, but you have focused in on the estate planning area.
Oh, yes.
Yeah, you don't do
Since the late
family
80s.
law, corporate law. You
No.
focus in just on the estate planning area.
That's correct. My particular areas of expertise are estate planning and trust administration. I do meet with clients who come in on probate matters, but I will hand that to our probate department.
Yeah. So you put your client's interests first.
Absolutely.
You're not you're compensated by salary. How does the firm charge their clients?
So for trust administration, it's an hourly rate. And so there's some attorney involvement for sure, obviously, but trust administration is a lot of paralegal work. So thank goodness for the client, and their paralegals are billing at a lower rate. Our estate planning is done on a flat fee basis.
So
So
let's say,
the
so let's
client
say,
knows what their fee will be before we engage into the work.
okay, I have $1 million estate. I am married. I have one bank account, one property. Approximately, what would you charge?
So we do it by on an estate plan basis. It's not just for the trust. It would be the trust, the
Correct.
wills, powers of attorney, healthcare directives. We transfer the house into the trust. We give you transfer instruction letters. So for the entire plan, single people would be around 4,600, and then married couples, depending on not the size of the estate, but their choice of complexity of the trust that they want us to draft for them. So a quote unquote simple trust, and we'll talk about this later, that would be in the area of 5,000, and then maybe 5,500 if you were doing a more advanced planning or estate complex trust.
Yeah. And then you don't sell insurance, you don't
We do
sell
not. Nope.
securities, etc. You just focus in on the
We practice law, and that's
I
it.
practice law. That's the good news. Okay, let's get into let's get into the program.
Okay, so we're starting here. If anybody wants to look, I went to Pepperdine, and I went to Pepperdine when Pepperdine, the law school was in Anaheim. That tells you how long ago that was. My tuition paid for the Malibu campus, which is beautiful. So a moment ago, I was alluding to the fact that when we do work for people, we don't do it piecemeal. We don't give somebody a trust. We do an estate plan. We're looking to cover you in life and in death. And when I say in life, while we're alive and well, we don't need an estate plan today. But if we become incapacitated, if we pass away, then we've got the bases covered. There's somebody that can take care of things for you, and things will go as you wish.
Well,
So that's what we're looking at here when we talk about an estate plan.
yes. Go ahead and get your outline up on the screen, share, and
Oh,
then
that would help, wouldn't it?
yeah. One of the things is that you're absolutely right, Cheryl, that most people think that estate planning and a living trust and a will are all about death. And especially a living trust, it's become so important because if you're single or you don't have anyone, the last thing you want to do is be without these documents.
That's true. Statistically, you've got a far greater chance of becoming incapacitated than death. You're only going to do that once.
Yes.
And so this is one of the advantages that we'll talk about that a trust has over a will. Nobody looks at a will until you're dead. But if you are incapacitated, there still needs to be somebody handling your finances, filing your taxes, and taking care of your business. And so a trust enables a trustee to step up and do a lot of that for you. With either a trust or a will, there is a document that we include that's called a personal property memorandum. And usually a trust or a will say, we're within the body of that document, we're not talking about who's going to get the porcelain doll collection, who's going to get the picture of grandma over the mantelpiece, those kinds of things. If you had to keep going back to the lawyer, that could get very expensive if you wanted to add to the document. So usually a trust or a will say that you can leave a memorandum, and that would say who gets the property when you pass. Now, this is personal property. You don't leave gifts of businesses, real estate, or cash. through a memorandum. Businesses and real estate, those are major assets. They have tax ramifications. Those should be handled either through the will or through the trust. Cash, from a practical standpoint, we're just concerned that if you leave gifts of cash on a memorandum, it's quite frankly, it's just too simple to add zeros after you're gone. So a $500 gift can quickly transform.
$5,000. Yeah.
Exactly.
Yeah.
So, but I
you
would
know,
say if you're gonna do a personal property memorandum, and they're often optional. If you don't fill them out, then the terms of the trust or the terms of the will direct the disposition of the personal property. But I will remind everybody, if you're going to fill out your personal property memorandum, please be specific. We had a gentleman here in Newport last summer, and he wrote on his personal memorandum, artwork to the neighbor. And we were like, and then he passed away, and we were, okay, artwork, does that include the pottery ashtray? Maybe, maybe not. And we definitely did not know which neighbor. So you want to be very specific. You want to, don't use pronouns when talking about, don't say brother, cousin, friend, neighbor, names. And be
names.
very specific. Yeah.
And by the way, I encourage people when they get later on in life to give assets away in person, especially to family.
Yes.
You could hopefully they give you a nice thank you. And if they don't, then you'll know what to do with the rest of your estate.
This is true. And you also have the, the privilege and joy of seeing them utilize the item, particularly if you gave a watch or a piece of jewelry or something.
Yeah.
And from a practical standpoint, Pete, you raise a good point that it also reduces the potential for litigation.
Yeah.
Because
personal property, it has a lot of emotions tied to it.
oh,
And
yeah,
people get
absolutely.
very emotional.
Yes, people will fight over, the crystal and not the Merrill Lynch account.
Yeah.
That's just,
Yeah.
the Merrill Lynch account is rather cut and dry,
Yeah.
but this is not. So
What I would also suggest is whomever you named as the trustee and be the final arbitrator over your personal property. And that way, but it needs to state such in your trust document.
in the doc,
It avoids the tension maybe that if you put two people in charge or you leave it open.
yes,
You got to give the trustee the final authority to make the decision.
this is true. And the use of the document itself does cut down on arguing because it's in your handwriting who you wanted it to go to.
Yes.
And so then they're not saying, oh, the trustee made this arbitrary choice.
Yeah. Well, I don't want you to spend too much time on the durable power because we went through that
Okay, great.
last week, and we also went through the advanced healthcare directive last week.
Okay, so we'll just say that those are two documents that are very important.
Very important.
Because again, statistically, you have a far greater chance of incapacity than you do of death. So you want to make sure that you focus on that and that you don't just do a will or just do a trust.
Absolutely.
So the common vernacular is to talk about, if you die, you have a will. But we find that a will, at least in California, this may not be true for every state in the union, but a will is probably the least effective tool if you're using it as your primary tool in your estate plan to transfer wealth to individuals. Both documents will say where you want the assets that are in your estate to go. Both require some administration, both cost some time and money. Usually a standard clause in a will is that the executor does not have to post a bond. What is a bond? It's like an insurance policy that if your executor ran off and went to the Tahiti with the assets in the estate, then the bond company would pay what the value of the estate is.
I've finally got involved in one case where the trustee ran off with the monies.
Yeah, really?
Yeah, yeah.
Wow.
And
Okay.
it was a court controlled trust.
Really? That's
Yeah.
surprising. Okay.
But
Well,
it's very rare that it happens.
very rare. I mean, theoretically, you're not choosing somebody that would do that for you
Yeah.
to be your executor or to be your trustee.
It, it,
And
does the
again,
will does the will have any control over assets during your lifetime?
see, that's one of the downfalls. So the will, as I mentioned, nobody looks at a will until you're dead. Even you don't look at your will. You know what it says. It's not exciting, and we know what the ending is. So most people sign the will, put it away, and they don't look at it again. The trust has the distinct advantage, though. In a trust, there are three characters, if you will. The settlor is the creator. The trustee is the manager. The beneficiary gets to use everything. And while you're alive and well, typically you're playing all three parts, wearing all three hats. But if you become incapacitated, in your trust document, you select who will stand in your shoes as the trustee and continue to manage the estate for your benefit. And then if you get better, you come back. But if you don't, as a trustee, but if you don't get better, then, and you pass, then the trustee will pay off debts and taxes and distribute the assets to your heirs. So the trust has a distinct advantage over a will in that regard. The other very compelling advantage and the primary reason that there is the proliferation of trusts in California, as opposed to maybe some other states, is that a trust does not go through probate when you pass. And if you're alive, the trust avoids conservatorship because you have this trustee that can step up and handle all of the assets that are in the trust. Probate is the legal process that occurs when somebody passes away. And so in California, the problem with probate is that it's when we're looking at what is the definition of a good estate plan, that is going to transfer the assets to the people you want it to get to or the institutions that you want it to get to with the least amount of time and the least amount of money attached to that. Both a will and a trust are going to take time to administer. Both a will and a trust are going to cost some money to administer. It's how much are we talking about? So here on this next slide, and I apologize because the law just changed on this, but it's so new that we didn't have a chance to update the slides. So there is a cutoff for probate. If you have a small estate, California does not want to probate small estates, but their definition of small is pretty small. So first of all, for the personal property, the slide is showing you that if your estate's under 184,500, then the estate will not get probated. As of April 1, now they do this every April 1, every 3 years. It's an appropriate day, April Fool's Day. They raise this cutoff for probate. The new figure, so those of you who have downloaded the document can write this figure down. The new figure is 208,850. The reason we get these stupid numbers is that these numbers are indexed to inflation. And you can see that we've had a lot of inflation. I was hoping we'd get closer to the 200,000 mark, and here we're over. It's 208,850.
So talk a little bit about people, their next point there, it governs property in your own name. So
yes,
that's where title comes in.
very,
Talk
very
a little bit
important.
about that.
Yes, so if you have assets that are in a trust, that's not part of the 108 or 208,850. If you have assets in your name alone and you have a beneficiary, so this would be things like your life insurance or your retirement plans. Most retirement plans require that you put a beneficiary on it. If you don't have that, or you're not sure who your beneficiary is, go check that and make sure that there's a beneficiary on there, because the assets that have beneficiaries, they're also not part of the 208,850. Those companies know who to pay, and they're going to honor that contract that they have with you, even though you passed away. Also, if you hold assets in joint tenancy, I'm not a fan of joint tenancy. If we've got time, I'll go back and talk about why. But one of the advantages to joint tenancy is that basically joint tenancy, whoever lives the longest gets it, and they don't have to probate it. So if you have, when we're talking about the 208,850, we're talking about the asset is in Peter's name alone. It's not in the trust. There is no beneficiary. It's not in joint tenancy. So then the account administrator, be that a bank or a brokerage or whatever the account is held in, they don't know who to pay. If you have assets like that and we add them all up, by the way, this isn't 208,850 per asset. It's the total amount of the assets that are in your name alone. If that is under 208,850, we can still move the assets without a probate. We can do that with an affidavit. Most of the big banks have their own affidavit forms. So if you do have a will, your executor would walk in, or even your trustee could walk in and show them the death certificate, show them the will, and then and you sign an affidavit that says, under penalty of perjury, that the estate is under the 208,850. I do want to point out, and again, because the law is so new, it's so new, the court doesn't even have forms yet, but we anticipate them very, very quickly. A brand new law has carved out also an exception for real property. So remember, the 208,850 is for accounts and assets that you have like that. But for real property, this new law allows, as long as it's their primary residence and as long as the gross value of the residence is under 750,000. Now, we're not going to see a lot of those in Orange County or even Southern California for that matter. But this is a brand new thing where you still have to go to, you still have to file paperwork with the court to move the property, but it is not a full-blown probate. And Pete, I want to back up for a minute and well, we'll talk about it, I guess, in a minute. Yeah, we'll talk about why we don't want to go through probate. So the advantages of a will, it's better than doing nothing. If you use a will, at least the court knows who you want to be your executor, who you want to manage things. They know who you want to get the property. If you use a trust, we don't have to go through a court. And we're going to find out that the trustee, I tell my clients, think of a trust the way you think of setting up a corporation. And you will recall that when Steve Jobs died, Apple didn't stop. Why? They have another CEO, and the CEO goes on, the company goes on. With a trust, it's very similar to that. You are the CEO while you're alive, and then your document names who's going to stand in your shoes and be the successor trustee, and they will follow the terms of the trust. We don't need a stranger in a black robe to tell us who's going to get what. The trust already says who's getting what, when they're getting it, how they're getting it. So we have those advantages. So what if you do nothing? You don't do a will, you don't do a trust. Well, it's the same as doing part of the trust. It will end up in your probate estate. Again, unless it's under the 208,850. And if you do nothing, you may have heard the old saying that if you haven't got an estate plan, the state's got one for you. They do. And this is called California's rules of intestate. The word intestate means you did not leave a will or a document, a testamentary document saying who gets what.
You know what's
And
amazing, Cheryl, is that there's still a majority of people who do nothing.
there's still a majority,
Yeah. Yeah.
Yeah.
I think it's because death, that's something that's difficult to to discuss. I
Yeah.
think too is that procrastination. You know,
Yes.
I'll get to it later. Um, and then also the decisions that people have to make when they do an estate plan. And so a lot of times they revert to doing nothing.
Exactly. So I think you're exactly right, Peter. Young people feel like, well, they're bulletproof. It's not going to happen. Older people, like you say, it's not real comfortable to talk about this. And then the decision making is difficult. But what I try to tell my clients, because sometimes people do come in and they do get this deer in headlights. Oh my gosh, I've got to really say who's getting what and when and how, and sometimes for some people it feels overwhelming to them. What I remind them is that a revocable living trust, which will avoid the probate, you can change it.
Yeah.
That's why they call it revocable. You actually don't have to even keep it. I've never seen anybody revoke one. The exception to that would be if they were a single person, they might revoke their single person trust when they marry, and they might do a new one then. But we amend trusts all the time where people change. That's why they call them living trusts. Life goes on. And so maybe the person that was perfect to be the trustee when you were 40 and was your counterpart is not so great now that they're 80 and you're 80 and you want to choose somebody else to be the trustee. So we can make these changes.
But I love your example about the CEO, Apple, if you change. I look at the living trust to prevent a conservatorship, and we haven't talked about a conservatorship yet, but it's that ability to step in if you get dementia, if you have a stroke, Parkinson's disease. You have somebody who can step in and continue life, and that you don't have to end up in court. And so to me, the word living from a living trust is the key because it prevents so many problems.
You're spot on, Pete. And a conservatorship, just so the audience knows, is a probate. It's done in the probate court. It's just probate for the living. And the court is taking jurisdiction over the estate. They're appointing someone to manage your affairs, and they're appointing someone who manage your health decisions. There are two kinds of conservatorships, estate and health. And so by having your trust and your power of attorney, those two documents will take care of everything that's in your trust and everything that's not in the trust. So we don't need a judge to tell us about that. And your healthcare directive will direct who's going to make your healthcare decisions. So again, we don't need to go to court. Conservatorships are nightmares because they never end. Unless you get 100% recovered, they don't end. And the conservator has to go back to court every other year. Very expensive. And why do they go back to court? You remember the Britney Spears case. They got to show the judge that they're not overspending, that they're detailing down to the penny every cent that came in, every cent that went out. which you do want good detailing, but you don't want, you don't want everything monitored by a court. They're expensive. Lawyers are billing. We do bill at a lower rate. Most attorneys do bill at a lower rate for conservatorships. Not because we want to, but the court makes us do that. No, we want to. It's a sad affair. But the thing is, even so, if the hourly rates for lawyers, even at their reduced rates, is still a lot, admittedly. So you want to avoid that, and you can if you have a good estate plan for the most part. It's a common assumption because California is a community property state that your spouse would inherit everything. The minute you marry now, if you die, your spouse gets everything. Not really true. Sometimes, depending. And that's the famous answer all lawyers have, the word depending. But it's actually true here. The intestate share, that's because community property, you retain your interest in your half of the estate. Community property is all property that you acquire since the date of the marriage, unless you get it through an inheritance or a gift. So if you have community property and you've done nothing, then your spouse will get the community, your half of the community property. But what if you had property prior to the marriage? And what if you inherited property after you got married? That's your separate property. And your spouse wouldn't be entitled to 100% of your separate property. This is where, if you've done nothing, this is where the California intestate law would take over. So if you have a spouse and you've done no planning and you've got some separate property, then if you have one child, your spouse would get 50% of your separate property and your child would get 50%. If you have more than one child, and it doesn't matter how many more, there could be 6 or there could be just another one where you have 2, your spouse would be, their share would be reduced to 1/3, and the children, the children would be entitled to 2/3 of the estate. And if you've done nothing, by the way, when we're talking about kids, they inherit their share at age 18. I personally can't think of any 18-year-old that is ready to inherit much of anything. And most people, even people that have really gifted and talented children, they don't want to have their children who are barely entered into college, if they're going to college, being inheriting a lot of assets. First of all, it might dissuade the child from pursuing their education. Yeah. So with a trust, and even with a will, you can say that the estate goes a little later than 18. So I think probably I just explained this slide, but it's there if anybody wants to go back. It lays out the California intestate succession.
How you have title is really, really important. So
yes.
Most individuals who purchase a house, especially 10 or more years ago, put title to their house because the real estate agent recommended it. And real estate agents at the time do not practice law, don't know anything about probate. And so they were recommending joint tenancy a lot. And there's all sorts of problems with that, and we'll get into it towards the end. But there's also another title that is better than joint tenancy if you don't have a living trust, and that's community property with right or survivorship. But there's, if you can hold title to property in your own personal name, you can hold it in joint tenancy, you can hold it as tenants in common, you can hold it as community property with right of survivorship, but the best way to hold title to property is in a living trust.
That's correct. It's 100% correct.
And let's say you're on your second marriage, or you get married later on in life. is it practical to have more than one trust, or should you just have one trust and it states in there what is separate property and what is community property?
It's a good question. And I tell my clients there's no real right or wrong. I always feel that all estate planning boils down to one's personal philosophies. I do think that if you've got the separate property, having your own separate property trust clearly delineates and outlines the assets that are your separate property. That said, I have had some people want to have a joint trust when they marry. And you can hold your separate property in a joint trust, and you can label it and identify it as your separate property. So it's really,
You
it's
could have a
really just a
choice.
matter of personal choice.
Yeah. What if, let's say, you want a living trust, and one of the questions was this is that, but I want to give my house, it's less than 750,000. Would it be a good idea then to label the trust outside of the trust?
When you say label the
Paid on death, or
you can.
some kind of a,
California does have we don't see much of it, but it's there. You can have a transfer on death designation on a deed, so that it would say you're holding title to the house, and you can say that it goes to so and so on your death. It actually says it on the deed. The reason we don't see it much is that people usually have more than a house. So it just doesn't, it makes way more sense to have a trust and have the trust own the house, and then the trustees managing the house and the assets, and then the trustee has access, because again, you don't die and then the next day they distribute the assets. It doesn't work that way, whether you've got a trust or whether you've got a will or nothing. All of this, there's a period of what we call administration. And when there is a trustee, when there is an executor, or if you do nothing and we end up in court, they call the person who's managing things the administrator. It's just a different name for our executor. They've got to make sure all the debts are paid. Some people erroneously think, oh, if I die, I don't have to pay the Toyota off. That's not true. Toyota still gets paid. Or I don't have to pay my Visa card because I died. No. When a person dies, the creditors are still very much there, and they're entitled to be paid.
just so
So
we're
if
going to
you've
talk
given
about,
away assets, transfer on death, then how does the trustee have the money to pay off these debts?
we're going to talk about trust administration in the last session, but you're right on, because it takes 7 to 11 months generally to administrate a trust. The other key, but wanted to get back to your CEO analysis, because if I recommend usually that people name the living trust and put all of their assets in the name of the trust. How do you do that?
So what we do is, well, first of all, if you've got real property, and when I say we, lawyers, it doesn't have to be Ferruzzo or me, but your lawyer will typically transfer the real estate into the trust for you. It's a deed. We transfer from you to you as the trustee of the trust.
LLCs, partnerships, the same way.
LLCs, partnerships, we do a one-page assignment, and we assign those interests over to your trust. We give you, usually lawyers give the clients transfer instruction letters that you can give to your banker, your broker, your managing partner for future assets. Let's talk for just a minute about what a trust doesn't own. The trust cannot own a retirement plan. Only a human being can own a retirement plan. That's because only a human being can
Yeah,
retire.
we're going to talk an hour and a half on retirement plans, just so you know.
Yeah.
So, but that's a great thing for people to realize. Retirement plans do not belong in a trust.
Right. And I will leave it to your seminar to go over whether the trust should be a beneficiary. This is a very complicated area.
Yeah, that's why we're going
Generally
to do an hour and
speaking,
a half on it.
yeah, exactly. Generally speaking, spouse first, maybe trust second as the beneficiary, but the trust doesn't own that. But usually if you go to a good estate planning lawyer, they're going to give you the instructions, letters on how to take title. There's a document we give you called a certification of trust, and you give that to your escrow officer when you buy a new piece of property, or you give that to the banker and it says, here's how to take title to the trust. Does everything have to be in the trust? Well, the other thing that many people don't put in their trust is their personal checking account. And the
But I don't
reason
see why they don't. They should. You don't
Well,
have to
if we
have
were
them.
good boys and girls, but from a practical standpoint, Pete, I will tell
Yeah,
you, I don't have mine in,
yeah,
and
I
here's
do.
why.
Yeah,
It's not a bookkeeping thing for the
yeah,
bank. They
yeah.
do make you open a new account. This means that if I put my bank account in the trust, now I've got to notify my water department, Netflix,
Oh, okay. I see what you're saying.
everybody that's auto debiting. And my checking account has never been $208,850.
Yeah.
Maybe one time, it was April 14th. I did not know that the IRS also uses Bank of America. That money was in and out so fast, it was unbelievable. But
Yeah.
generally speaking, and here's the thing, and the reason I don't worry about my bank account not being in the trust, I have a beneficiary on it.
Yeah.
So, if you put a beneficiary on your bank account, they just walk in with a death certificate and then that takes care of that.
Yeah. For more for practical, reasons, try to simplify it, put all your assets in one trust, because it's easier if something happens to you during your lifetime for the
Yes,
next individual who steps in to be the trustee to settle matters. Also, when you put some assets in another trust, or put another asset in joint tenancy, or you put another asset in a transfer on death, it's very hard for the next individual to manage, and you don't know what's going to happen to you in the future. So keeping it simple, stupid is most times the best way to do it.
yeah,
And it saves you money.
yes, I couldn't agree more. So we're agreed that doing a will is better than doing nothing because then you have a say-so on the disposition of the assets. But the problem is if you do a will or you do nothing, either way, your estate, if it's over the 208,850, now it's going to be probated.
Is it easier to challenge a disposition from a relative, whether it's a trust or a will?
Not really.
It's the same, isn't it?
Yeah, yeah.
If somebody's
I
going to
mean, there are
challenge,
only 5 grounds for disputing a trust or a will. Those 5 legal grounds, 2 of them we hear about a lot. The other 3 you hardly ever hear about. So the other 3 to begin with is fraud. I hand you this piece of paper and I say, hey, would you sign this receipt? But actually what you signed was a will. That you could, that would be grounds for a contest.
yeah.
Mistake. I thought my son was killed in the Iran or Iraq Afghan war. And so I did not include him in my trust or in my will. Turns out he wasn't. He was just a prisoner of war. Then he could come home and he could contest because it was a mistake. I thought he was gone. Duress. I have a gun. You will sign this will that is naming me as a beneficiary. All right, that can get thrown out. The 2 where we see almost 99.9% of the litigation is, it's corny as it sounds. You have to be of sound mind to do a will or a trust. You have to know the nature of your estate. and you have to know who are the people that you are giving the assets to.
You have to have capacity.
You do. That's what they call it. Testamentary capacity is what they
Yeah.
call it.
So,
And then the other one is, well, before we go to the other one, so we'll see allegations that, oh, the decedent was an alcoholic, didn't really know what they were doing. The decedent had Alzheimer's, didn't know what they're doing. The decedent died of a brain tumor, so he couldn't have known what he was doing. So we see that's where the litigation comes in.
yeah, and a problem relative is not going to cause a problem within a living trust because of any of those issues that you had just brought up.
Right, right.
So,
And then the fifth element is undue influence. And we're seeing more and more of this. This would be where the caretakers are getting all of the
or
estate.
one family member is living with mom or dad, and all of a sudden the trust is changed.
Mhm.
That's the kind of situation.
These situations, though, you're going to find whether you do just a will or whether you do a trust.
Yeah.
Those allegations are going to be the same. If you've got that in your family or in your situation, it's going to be the same either way you go. We do, sometimes we will ask clients, hey, especially if a client comes in and says, I want to disinherit somebody, then we'll say, that's fine, that's your right. California is very respectful of how you want to leave your estate. You can't leave it to terrorists. So if you were planning on gifting to Hezbollah, sorry, that is not going to fly. But other than that, you can leave it to whom you want. You don't have to leave it to your children. You do not. But what we'll typically do with a client like that, we will recommend that you do leave a letter that explains why you did what you did. First of all, that will exhibit to a future court that you were of sound mind. They don't have to like your reasoning. They don't have to agree with you. But they will know that you made a rational choice and that you knew who you were, your natural heirs. And then we'll tell them either you keep it, but we'd like to keep a copy in the file. I have had lawyers call me after my client dies. We're going to sue, we're going to do this. And then I say, you have to do you. Let me just email you what I'm going to show the court. And they go away.
Yeah. You mentioned a POD, paid on death, for your own personal checking account. We had a question on that. When would you do a POD and a living trust, which is obviously you have a living trust. Why did you do a POD on your checking account?
Again, just because I didn't want to have to open a new bank account. So I wanted to keep it in my name alone. I
And you
have
don't
a
keep
power.
hundred thousands of dollars in your checking
Yeah,
account.
no.
So it's a small amount.
It's a small amount, and I have filled out the bank's power of attorney because many banks will not take lawyer drafted powers of attorney. They want you to have their power of attorney. So if I did become incapacitated, my daughter could be able to manage the account for me and pay things because she's the agent on the power. And then when I die, she goes in with a death certificate and she gets the account.
Okay.
So,
And then if you have the account in joint tenancy, let's say with your daughter, you wouldn't have a POD because upon your death, your daughter would have that account.
That's true, but here's why I would never do that. Because the minute you put somebody on title with you, you just expose your asset to their debts. And I've had clients call me up, the IRS just put a lien on my account. I don't owe the IRS money. And then I start talking to them, oh, it's a joint account. What about, oh, it's with your son.
Yeah.
Maybe the son didn't pay his taxes.
Yeah.
Apparently not.
Please don't use joint tenancy with a son or a daughter. Just not very wise. I want to go back to this slide on probate. The cost of going through probate is paying the attorney and paying the fiduciary besides all the court cost.
That's correct. So there are two huge problems with probate. This is the first big one, and that is the cost. And again, We have a probate department and we like them, we will do them, but it's costly, which is why we like them. The lawyer's fee, you can see the example here on a $5 million estate. The lawyer's fee is what we call statutory. It's written in the law what our fee is. If you want to know how much it's going to cost, you can do this calculation yourself and you can see how much it will cost. It also means that when you die, your executor doesn't have bargaining power with the lawyer because they can't, if somebody doesn't like the fee here, they walk down the street, that lawyer is going to say the same fee. It's written in the law what the fee is, and it is a percentage based on the gross. This is the other thing, Pete. A lot of people think, oh, I've got a $3 million house, but I have a $2.5 million mortgage. So really my estate's only $500,000. That's not how they calculate it. They ignore the mortgage. They ignore all your debts. They add all of the assets up and then they base the fees on that. Mind you, they do exclude the assets that have beneficiaries. So if your life insurance has a beneficiary on it, that would not be probated.
And that's why a trust avoids the probate, because it's a contract. And
that's right.
So by the way, should family members who are administrators of a will or a successor trustee of a trust, should they be paid?
Well, they are called a trust. If you do a trust, absolutely the trustee should earn a fee. Should they earn these kinds of fees? No. They're not making these kinds of fees. As you can see, the executor in a will, if you do a will, the executor gets the exact same fee as the attorney. And we're using a $5 million estate, but for those of you with smaller estates, on a $1 million estate, the lawyer makes $23,000. The executor makes $23,000. This is a lot of money. Sometimes we're forced to have to sell the property to pay these fees.
But in addition, there's court cost, there's publication cost, there's
Yes.
appraisal cost, there's extraordinary fee, possibly. So
yes, and let me give an example of an extraordinary fee. If you leave minor children, we can go in, we're not going to wait 2 years to get money for the kids. We're going to go in right away and petition the court for what we call a family allowance. But we're going to charge extra for that because we didn't have to do it for the person who didn't have kids.
Yeah.
So we get what's called extraordinary fees.
And by the way, many of these costs are very similar in a living trust as well, but substantially lower because we don't have to go through the court system. Let's go to the next slide.
Yes. I want to say, yes, so we've kind of gone over this, that yes, it's cheaper. Some trust administration, it's going to still cost money, but it's nothing like what you just said. And then before we go there, I want to talk about one other factor that we don't have a slide for, but I think especially post-COVID, it's very, very salient, and that is the expenditure of time that it takes to do a probate. And Pete, you and I have been around for a while, so you know, pre-COVID, it was taking about a year in Orange County to get a probate approved and administered. But what happened during COVID is the courts shut down. And quite frankly, the Orange County court has never recovered. And there's a very quick reason for that. It has to do with the fact that all of us in America under Sixth Amendment, we have a right to a speedy criminal trial. So the court shut down in March 17th, St. Patrick's Day, did not reopen until August 26th. To give you an idea of the gravity of the problem for Orange County, these criminal trials, by April 15, not quite a month after it shut down, Orange County was behind 1,500 criminal trials and 12,000 criminal hearings. Now, stretch that out to August. When it reopens, they had, to borrow a medical term, they had to triage All the criminals are at the front of the line. See, there's no right to speedy civil trial. There's no right to speedy probate or small claims or traffic. So then you had your criminals at the front of the line, civil, small claims, traffic. Dead people all the way at the back of the line. So you guys don't vote, we don't think. So
Yeah.
it ends up that it is now, if somebody came in my office this afternoon and said I need to probate Aunt Millie's estate, we're gonna tell her 2 years.
Yeah.
And that
Plus years.
that means that nobody's getting money and not even the lawyer gets paid. Nobody's getting distributions until that case is done. And it's taking, and that's not a complicated estate. If you throw in the winding down of a business, or any kind of litigation, wow, it could go out for years.
So your bottom line here in Orange County is please have a living trust.
Yes,
Yeah, especially if you're single.
absolutely.
To have to go through a conservatorship through the probate court, you're just slightly ahead of the dead people, but still,
Exactly.
it's
And
a long
And
process.
to be fair, the court, especially in conservatorships, the court's very protective. So they're going to take care of business there, but they're not going to do it fast. It
Yeah.
just, you've sat in on hearings, Pete. How many cases did you hear the judge say, we're going to continue this? We're going to continue this. We're going to
Almost half.
continue this.
Almost half.
Yeah. And the
Okay,
lawyers
parties
are
to-
sitting there, hurry up and wait.
Parties to a trust.
Right. Okay. Parties to a trust. I alluded to this earlier. You basically have three parties, the settlor, and I apologize on behalf of my profession. Lawyers can't seem to agree on what to call half of these people. Settlors, you'll sometimes hear them called trustors, grantors, creators, settlors. They're all the same thing. It's
Big
the person who
OR.
created. Yes, any OR kind of person.
NEOR, owner.
Right. And then you have your trustee, that's the manager. They're making all the saving, spending, acquiring, disposing decisions that you're making every single day in your life anyway. And then the beneficiaries, they get to use everything. So once again, when you have a trust, you're wearing all three hats. You're the settlor, the trustee, and the creator. Married couples, usually the trust will say, doesn't have to, but usually says something happens to one of you, the well spouse acts alone. And then when something happens to both of you, the document says who will step in your shoes and be the successor trustee. And then, yes, unlike a will, we have to physically transfer the title. Once this trust is set up, we have to move the title and change from your name as an individual to your name as the trustee of the trust, so that you're managing the assets in the trust. The trust can hold 50 gazillion dollars. It'll never get probated. What you don't have in your trust, that's your estate. And that is what we will take care of with your will when you pass. And we do give you a will, by the way. When you do a trust, we do give you a will, but the will is super skinny. The only thing that the will says, if you have kids, it will say who's going to be the guardian, the person who's going to physically take care of the children. Doesn't have to be the same person as the trustee at all. Sometimes you have wonderful people in your life that will bond and really nurture and care for your children, but they have no financial savvy, so you wouldn't want them to be the trustee. But you can have that two different people if you want.
But the will becomes an emergency document.
And the will says, whether you have kids or not, all wills that are with trust, they say, I give everything to my trust. So these are called pour over wills.
Yes.
They pick up the assets you left out of the trust and pour them into the trust. Super effective. If all you left out was a $208,850, the wills still work if you leave out more than that, but then we have to probate them.
Yeah.
Okay.
Let's go to the next slide.
Parties to a trust, well, again, what is a trustee doing? They're managing the property. Their powers are identified in the trust. I can say that if you have a trust, your powers are pretty unlimited in terms of what you can do with your assets that are in your trust.
So in a trust document, the first thing that you usually see is a little bit of the history of the family. If you've been married once, naming the kids, and etc. And then right after that, usually you talk about the trustees a little bit. Who do you name in succession? Do you always name the oldest child in that you have, or
Definitely,
talk a little bit about that conversation that you usually have with clients about
sure.
naming the trustee?
This can be one of the more complicated or difficult decisions that people make because it is a big job, number one. And then there is, especially if you've got more than one kid, this can be a problem. Who can be a trustee? It can be an individual, and they can be family members, they can be friends. The problem we find with naming the oldest child or the boy is that it creates resentment. I've got a case right now where the one sister is the trustee and the other sister's like, but wait, why does she get to decide everything? And it's really kind of sad because you can see the relationships just fraying and falling apart. And this is something you don't want to have happen in your family. Let me tell you, when my dad did his trust, I drafted it. He's like, you're going to be the trustee. I'm like, no, I'm not going to be the trustee. Do you think I'm crazy? No. So yeah, you really want to think it through. If you've got a very copacetic family, then maybe that works. What about co-trustees? Yes, you can name all of the kids trustees. That can be incredibly unwieldy and inconvenient because then they all have to sign documents, they all have to make decisions. For these reasons, many times we recommend that families consider having a private professional fiduciary, certified professional fiduciary, or a trust company. Professional fiduciaries, Pete, maybe you can talk for a minute about what that
Yeah, I'd rather
is.
wait until the final session, and it sounds like that's because I am a professional fiduciary.
Yeah.
I don't want to promote myself.
Okay, well, I'll just say that these are people who are skilled, financially, very familiar with trusts. Many of them worked in banks or trust companies. They have years and years of trust experience,
Yeah.
and they know how to say no if they need to say no. They
Jim,
also make wise decisions. See, it's such a complicated job if the trust is going on. Now, if it's just we're going to pay debts and taxes and then we're distributing out to everybody, that isn't always the case. Sometimes the trust says we're going to hold for the children. We're going to hold, especially minor children. Again, we're not giving 18-year-olds money to buy Ferraris. So if the trustee's going to hold, they have to be thinking about earning interest and income for the beneficiary. And then there are remainder beneficiaries. We'll get into that later. So you really need somebody that's pretty financially savvy, or if they're not, they know that they're not, and they get a good team.
talk a minute about fiduciary liability.
So a trustee is a fiduciary. A fiduciary is someone who's taking care of something for somebody else. One of the big things that we stress when a client comes in as a trustee and they're going to be a trustee, we tell them you are personally liable for all of the decedent's debts and all of the decedent's taxes to the extent that there's money in the trust to pay for it. Obviously, if dad didn't pay his taxes for the last 12 years, the IRS can't come after the son who's the trustee and go after that. But if there was money in the trust when dad died and the son could have paid the taxes with the trust money and the son didn't, now the IRS can come after the son. And likewise, if the son doesn't pay the creditors, if the son doesn't distribute in the exact manner that the trust directs that the son distribute, then there's personal liability. It's not an easy job. It is fraught with a lot of things that people don't know. For example, there's a notice that has to go out to the beneficiaries within 60 days of the date of death. Most kids don't know that. So they don't know what they don't know. And that's why if you are thinking you absolutely want to have family member or friend do this, make sure that you leave them a good team. They have a good attorney, a good CPA, and maybe a financial advisor to help them through it. But if you have a professional fiduciary or a trust company, they know how to do these things. And at the end of the day, sometimes people think, well, if I choose my kid, I don't have to pay the family member, the family member doesn't have to get paid. Well, yes, they do. Even if your trust says the trustee does not get a fee, California law says, yes, they do. So they can get it. Now, of course, your child can waive the fee, but I can't tell you, Pete, how many times kids have come in and said, oh, I'm not going to take the fee. At our first meeting, I talked to them, you'll be entitled to a fee. Oh, I won't take the fee. And
Yeah.
I always
At the
tell them,
end, they'll take the fee.
wait till we get to the end.
Cheryl,
Let me tell you.
we've got 10, 11 minutes left.
Oh, we need to
And we've
move on.
got lots of slides to go through. So let's focus in on some of the important matters that people need to know.
Okay, so the phases of a trust, well, it's pretty obvious while you're alive, when you pass away, if you become incapacitated. The trust can be there in all of those, is there in all of those situations. The trust contains divisions in the trust or sections in the trust that talk about what happens if you become incapacitated, what happens when you die, and who gets what after you die. Again, the trust can say outright distribution for the beneficiaries, but if the beneficiaries are minors or you have other reasons why you might want the trust to continue after you're gone, then the trust can direct that. During your lifetime, again, you're the trustee. You're making all of the decisions, whether to save, spend, acquire, destroy, improve. You name a successor trustee, and they would only come into the picture while you're alive. If you resign, I do have a number of 90-year-olds lately that have decided they just don't care anymore. They don't want to run their estate, so they'll resign, and then their successor will step up. And also, of course, if you become incapacitated. So then there would be, during the lifetime, or how does the trust work? You're the trustee while you're alive. If you become incapacitated, successor trustee is managing the trust. Then after you pass away, they're paying off debts and taxes, and then they're making the distribution to the beneficiaries according to the terms of the trust. So for married couples, I have to preface my comments by telling you there are a number of different kinds of married couple trusts, and it would be worthy of an entire other seminar to go over all those different kinds of trusts.
But I want you, I want to point out that the beauty of a living trust is that it can take care of family situations. Usually it used to be that living trust was all about taxes. Now it's about your family situation, whether or not you have a spendthrift child, whether or not you're worried about one of your daughters marrying a bully, whether or not you have a spendthrift. A living trust can take care socially of your family, but you need to fully let Cheryl or your attorney know what your family situation is like.
This is true, and this is true even as between the married couple, Pete, because as you point out, the reason that trusts are not as concerned for the majority of people with regard to tax anymore is that the federal estate tax exemption is shot up so high. That will change. but it's probably, especially given the current administration, it's probably not going to reduce. So for the average person, we're not as concerned in drafting the trust for the tax reasons as we are for the social reasons. And what I was going to say is, as between spouses, a lot of times when people come in, married couples, they haven't really thought it out. Because I will say, if we do a simple trust, so in a simple trust, so the two of you are together, something happens to one of you, everything goes to survivor. This whole part of the trust where the trust breaks off into, that doesn't happen. The trust remains one cohesive trust. Everything goes to the surviving spouse. But that means the surviving spouse continues to be able to amend or revoke the entire trust. And so if you have children from a prior marriage, or if, let's say you don't have any children at all, but you look at your spouse and you think, hey, I think they're pretty cute. I think they might remarry. And then my part of the estate could end up with somebody I don't even know right now. If there's something like that, then maybe we don't want a simple trust where everything is going to survivor, and maybe we do want the trust to divide into sub-trusts so that there's some control over what happens to the deceased spouse's half of the estate. That doesn't mean that the surviving spouse doesn't get to use the assets in the sub-trust. So we would have, in this slide, this is an example of a more complex trust. Surviving spouse, in their survivor's trust, they would have their half of the community property and all of their separate property. And then in the deceased spouse's trust, they might have a bypass, they might have a marital trust, but their deceased trust, usually, unless you tell me to draft it differently, usually the surviving spouse is still the trustee of both of the trusts, the survivor's trust and the decedent's trust. And so they've still got management and control. Usually they can still access the decedent's trust for all of their needs, health, education, maintenance, support. So their survivor's trust, they can do anything they want with it. They don't have to invest wisely. They don't have to, they don't even have to keep it in the trust. They can revoke it. They can amend it, but they cannot amend the deceased spouse's trust. So this is the kind of trust where we would be looking at if you had children from a prior marriage, perhaps. So again, this is a really simplified, very simplified. I mean, there are disclaimer trusts and there are Clayton trusts and there's just all these different kinds of trusts for married couples. It's worth it to sit down with your lawyer, have these discussions. They're sometimes awkward, but they need to be talked about because we all know nobody's getting out alive. So we've got to face reality. And with your spouse, what do you want? What is it that you want? How do you want it to go down? And if we can lay it out so that it's clear and easy for everyone to understand. And
Yeah.
again,
And remember the
go ahead.
the CEO concept. I love that. Somebody to step in the event you become disabled for any reason, and it's so smooth because you don't have to go to court. Just the your successor trustee, goes to the bank and gives a doctor's letter and their driver's license, and they step in and continue, buying groceries for you. They can pay your taxes for you. Your life continues. And so I look at a living trust as almost a social mandate here in Orange County. We're not Kansas where, you can go, hey,
Yeah,
we
because
know each other.
not all states have this ridiculous probate system.
Yeah.
Texas, Colorado, they have what's called summary probate, and you actually can get through their process in about 2 or 3 months. Here,
Here,
it's just not, it's not very
feasible.
responsible if you,
Yeah.
especially if you have minor children,
If
to
you
not
have a
have it.
living trust that, let's say you move from out of state uh, into California or or you have properties in other states, will a living trust avoid probate in all the other states, or should you redo your living trust if you're here in California?
So great question. It's a two-parter. All states will recognize your trust. If you moved here from Missouri and you've got a Missouri trust, should you have a lawyer look at it? And vice versa. What if you moved to New York from California? Should the New York lawyer look at it? The answer is yes. I'll tell you why. Most trusts say this trust is governed by fill in the blank state law. So in California, we say this trust will be governed by California law, which means that if you die in Missouri or New York, they have to administer according to California law. So that, and in a trust that we're drafting in California, we're talking about community property within the trust, but there are only 9 community property states. So the short answer is yes, it will avoid probate, but if you don't have it looked at, it could be a more difficult administration than if you had it looked at and amended.
Cheryl, we're coming to the end. Why don't you put your the last slide on the board so that people can contact you if they need to. If any of the attendees have a personal question, can they email you?
Absolutely,
And
yes.
so, your normal hourly rates are what, Cheryl?
So my hourly rate is $5.50.
Okay, so but if you have a follow-up question to today's session, she's not
No
going to
charge at
charge
all.
you.
No charge at all. And I make that good for the next 2 weeks. No charge.
Okay,
Okay,
so that's very rare. So thank you, Cheryl, for doing that.
sure.
Fuad, do you want to open it up? If anybody has a verbal question, they can ask away. This has been
Sure.
a complicated session. So, in the event anyone has a question, how would they do that, Fuad?
Well, let's start off by thanking everyone for watching. If you're watching live right now, please stay with us for the live Q&A. But for anyone watching this video in the future, thank you for watching. Stay tune in for next video, which will be retirement asset planning with Michael Simon, and we'll see you next time. Thank you.